you are called upon by section 8 to rise up to the occasion in the event there is ineptness on one part of state organs. And besides that, I may invite my learned friend, Mr. Kihara. Article 10 places you on the same pedestal with the parliament. Because this court and parliament is bound up by that provision. So where there is ineptness and negligence on the part of parliament, the court of law can rise up. In any case, the application of section 7 vis-a-vis section 8 of section 7 to the 6th schedule vis-a-vis section 8 of the Magistrates Court Act can only be applied by this court, not parliament. So we invite you, Your Honor, to find that there is no offense that has been disclosed by this particular charge sheet. The same is meant to achieve ulterior motives other than that which is contemplated to protect public interests. It is meant to preserve personal egos. It is meant to preserve at a certain equilibrium for which you do not understand personal emotions. Unfortunately, these are court of law. If anyone feels injured by these particular statements, the recourse is not before you. The recourse is not to criminalize utterances that are constitutionally protected. When you retire, you look at Article 19, 20, 21, and 27 of the Constitution. I invite my light for you. Yes, Article 10, Article 19, Article 20, 21, and 27. And finally, Article 33. But also, look at Section 89 of the CPC, when a court can decline to admit a charge. Allow me just to read it as I invite Mr. Kihara. That is Article 90, Section 98, 89, subsection 4. The magistrate, upon receiving a complaint or where an accused person
News will invest 2.5 billion shillings to boost agricultural funding for small and medium enterprises in Kenya. The fintech says that this will help boost funding to bridge the over 3.66 trillion shilling gap between agriculture's contribution to the economy and the credit it receives. Despite agriculture contributing 26% to Kenya's annual wealth and providing 1 in every 10 formal jobs, the sector currently receives only 3.53% of private sector credit, amounting to 134.2 billion shillings out of a 3.8 trillion lent to the private sector, according to data from the Central Bank of Kenya. Avenue's country manager Emmanuel Murai says the fintech will leverage technology to enhance access to credit.
Technology to manage loan portfolios and also to access the data in order to assess the risk more properly or more holistically, specifically for the agri-sector.
I'll be giving you reasons why we should not admit this charge. This charge is drawn and it is alleged that the person before you has done something contrary to Section 94, subsection 1 of the Penal Code. And Your Honor, that is the section which I've opened. That section, and if I may just read the words that are in the charge sheet, that Jayne Kihara on 8th day of July 2025 at Nairobi City within Nairobi County, being in a public gathering, uttered the words to it. Now the words are there, the paragraph is there. It concludes, with intent to provoke breach of peace. So, I submit that that charge, as drafted, does not disclose any offense under Section 94, subsection 1 of the Penal Code. These are the reasons. That section reads, a person who in a public place or a public gathering uses threatening, that's one, abusing, that's the second one, or insulting words or behavior. So the operative words here are, those words must either be threatening, there is no suggestion that she used any threatening words, abusive, it is not alleged she used abusive words, or insulting words or behavior, it is not suggested that she used any insulting words. And then that is when an offense is constituted. So the charge that is before you does not have threatening, abusive, or insulting words or even behavior that would go on and cause breach of peace and all that. So basically, the offense that is before you is horrible. The other part of the section is just saying how minor that offense is. It's just a fine of 5,000 shillings.
Can you address the other element?
Yes, I'm coming to that. I just caught my eye in the fine, which is 5,000 shillings. So, then, with threatening, abusive, or insulting words or behavior, is no suggestion that has taken place, with the intent, one, to provoke breach of peace. That is the one that has been taken. So that for you to have an offense where the intent is to provoke breach of peace, those words or that conduct must fall within the three parameters, or any of the three parameters that I mentioned. What is before you does not fall under any. Under subsection 2, the Act then defines what is a public gathering. And what you will find is that one situation where there is a gathering is when there is any meeting. So basically, when a charge reads a public gathering, a prosecutor must take the charge to what kind of a gathering. Is it a meeting? Under paragraph A. Gathering or concourse of 10 or more persons in any public space. So you're not being told, were they 2 people? Were they 1? Were they 3? Because the minimum number is 10 or more. And it must also be in a public place. This charge does not say the public place or any place. We are just being told in Nairobi. All of us in Nairobi. Yeah, even here is in Nairobi. So, which is the public place? So, that way, the offense is not disclosed. Paragraph B. Any meeting or gathering which the public or any section of the public of more than 50 persons are permitted to attend or do attend, whether on payment or otherwise. There is no suggestion alleged she used. It's not been indicated whether there were 50 people, whether these people paid to be there, they didn't pay to be there. So what is Honorable Jayne Kihara supposed to defend? And then these particulars are not in the charge. And finally, the other situation is the paragraph C. Any procession in, to, or from a public place, any procession moving in or out of a public place. We are not told that these words were uttered in the investigations. You know, when a charge is brought before you, I'm coming to that. I just under section 94. Sorry. Under section 134 of the CPC. With the intent to provoke one thing that should stand out is the following: that every charge for you to have an offense or information shall contain and shall be sufficient if it contains a statement of the specific offense or offenses with which the accused person is charged, together with such particulars as may be necessary for giving a reasonable information as to the nature of the offense charged. The information that is contained in this charge, Your Honor, is insufficient under subsection 1. It is insufficient under subsection 2 of section 94 of the Penal Code. Would it be right then if I shift to that point? Your Honor, when a charge, and the section which you have just referred to, that is section 194, is indeed the section that implements the provisions of Article 50, sub-Article 2, paragraph B of the Constitution, that provides that every accused person has a right to a fair trial, which includes the right to be informed of the charge with sufficient detail to answer it. The charge that is before you does not have sufficient details as defined in the implementing statute. So if she goes ahead and pleads, the judge has brought before you, it will be a violation of Article 50, Article 2, paragraph. And important to mention, Your Honor, that under Article 25 of the Constitution, and for emphasis, I want to read what it says, that despite any other provision in this Constitution, the following rights and freedoms shall not be limited. These are rights which cannot be limited. And one of such is the right to fair trial. That is paragraph C of Article 25. The right to fair trial is the one that I talked about under Article 50. So you are then placed in a position where you have a charge that is in contravention of Article 50, and you're being asked to allow a person to plead to those charges. Your Honor, decline that invitation. And Your Honor, I do not want to talk much because before we came here, we were before you again in another matter with the same prosecution team and Mr. Mageto for Honorable Bongori. And yesterday is very, very late because we were at the DCA headquarters to deal with an issue of Honorable Bongori. And now, if it now went to the other day, then yesterday we were dealing with Jayne. And now, so that Your Honor, I don't want to tire you because you're also very, very, very stretched. But the context of that is that there's a pattern, and this court should rise to the occasion and see what is happening and uphold the Constitution. And that will be done. And I invite my friend, our chairman, Mr. Mbogo Wanjohi, to make something.
No, Your Honor, that is not the introduction they give to our chairman. This is our chairman of Gema Wado, which is an organization of about 6,000 lawyers. So you cannot just give that introduction. Please.
Well, it's another thing to
We have an association which has about 8,000 lawyers practicing in Kenya, others in Kenya. It's called Gema Wado Association. Very many lawyers.
What he's not telling you is that he has now incorporated our cousins from Mount Kenya South.
Is our able chairman.
Thank you. Colleagues for that introduction. Your Honor, again, my name is Wambo Wanjohi, and allow me to concur with what my senior, Mr. CM Kihara, said, and what the state is doing. The state is using fire extinguishers to blow out a candle. Section 94 was meant for brawls in bars and fist fights in funerals. That is the purpose of Section 94, the penal code. But, Your Honor, let me go into why these charges before you are defective. Number one, Your Honor, there is no clear offensive conduct that has been identified. Section 84 says the charge itself is offensive conduct conducive to breach of peace, contrary to Section 94 of the Penal Code. Whether the charge does not specify what part of the charge was actually offensive. And a simple reading of these particulars. I will just cherry pick some. I would say I want to talk about Naivasha because I know the goons were transported in NYS bus. How is that offensive? I want to tell the president, this is not about the young people who you went around promising heaven and what you are digging deep so that they go under. It will not happen. How is that offensive? Number two, if the president has been mentioned in this particular charge sheet, he is not among the witnesses. You see the complainants? Second, Your Honor, the use of vague words like offensive conduct without defining how and why it was offensive makes the charge overly broad and ambiguous. Secondly, Your Honor, no particulars of breach or threat to peace has been disclosed. The charge alleges intent to provoke breach of peace, but fails to state the following things. What disturbance followed, if any? Who was provoked? What specific act of violence or disorder was caused or threatened? There is no breach of peace in these particulars that accompany this charge. Third, Your Honor, we submit that speech alone is not automatically conduct. Section 94 is meant to criminalize conduct. It is clear. Offensive conduct conducive to breaches of peace. It does not criminalize opinions and political expressions. If the charge is based solely on speech, then the prosecution must show that the speech had a clear and present danger of causing peace. This threshold, Your Honor, has not been met. Fourth, Your Honor, we submit that no manslaughter is alleged, save for with the intent to provoke breach of peace. To which we say the charge does not state intent or even suggest that Jayne knew her words would provoke unrest. What she was doing was expressing her political opinions, guaranteed under Article 33. Now, Your Honor, fifth, we want to go to the issues of Article 50, 2B, and K of the Constitution, whereby the accused has a right to be informed of the charge in sufficient detail, presumed innocent, and not to be convicted for conduct that is not clearly defined as an offense in law. Your Honor, this charge is too vague and imprecise to meet these standards. Sixth, Your Honor, there is no link between the words and the alleged offense. Even if this speech was quoted in full, it shows no incitement to violence. Actually, she's even giving her condolences. As I condole with the bereaved, quote, and I also empathize with those whose properties were destroyed. So this speech does not show any incitement to violence or encouragement of disorderly conduct. Condolences, criticism of police, political frustration, how is that a criminal act, Your Honor? And if that was the case, I believe half of Parliament would be in committee. Seventh, Your Honor, as I conclude, this this is a gross misapplication of the Penal Code. As I indicated, this provision is for brawls in bars and fistfights in funerals, and it should not be used as a tool to criminalize free speech, however loud or uncomfortable it is. Finally, Your Honor, we submit that even if all these alleged facts were true, they would still not amount to breach of peace under Section 94. Which makes the charge fatally flawed and ripe for striking out at the earliest instance. This was submit.
You want to cede the floor for 1 minute to Councillor Iregi, and then
Your last one.
yeah, last one. Then I probably just wrap it up in a minute.
You know, the agreement was that it was 2. I know this is mathematics, and I know lawyers. It was 2 after council, and that's the third. So but we have no objection.
Thank you.
Just mathematics.
Thank you.
Mr. Wairegi.
Yes, sir.
So for 1 minute.
Yes, for 1 minute. I wish to address you on an issue that has not been addressed by my colleagues and seniors as to what should happen in the intervening period when you retire to render decision on the validity of the charge before you. You honor the charge as rightly put is one under section 94(1), a misdemeanor. And in light of the provisions of article number 49(2), a violation is ensuing at the moment in that our client is in custody. Article 49(2), the rights of an arrested person, provide that a person shall not be remanded in custody for an offense if the offense is punishable by a fine only or by imprisonment for not more than 6 months. The one before court is one that qualifies under 49(2). As such, in the intervening period, it will ask for release of the arrested honorable man on her personal property.
Your Honor, Honorable Jayne was apprehended in Naivasha in her constituency. And was escorted by a convoy of 30 officers, approximately, because she agreed us. Two Land Cruisers, Your Honor, and the famous Subarus. Only to be presented before you this morning, be charged with a misdemeanor. I believe it's on Saturday? Yesterday, Your Honor, lunch hour. When I spoke to her, she was at DCI headquarters last night. As senior counsel, I thought, from what she told me, we did not have to use public resources to come in this morning for a misdemeanor. So I tried to talk to the deputy DCI, who told me I was going to look into that matter. And if they had properly applied their minds, she should not be before you, Your Honor. That's our submission. Finally, Your Honor, I want to refer you to the provisions of Article 2 of our Constitution. Which of course declares that this Constitution is the supreme law of the Republic and binds all persons and all state organs at both levels of government. Sub-Article 4, Your Honor, of section of Article 2, any law, including customary law, that is inconsistent with this Constitution is void to the extent of the inconsistency. And any act or omission in contravention of this Constitution is invalid. Your Honor, my submission is that alleged breach of Article section 94(1) of the Penal Code is unconstitutional. Because in violation of the very constitution itself, and the honor, as Kenyans we should be very proud that we imported under Article 20, 19 and 20 of the Constitution, the Bill of Rights. Therefore it behoves all of us, Your Honor, our courts of justice taking leadership to ensure strict adherence with Constitution 2010 and its valuable provisions, which actually is a constitution that gives freedom of expression. We've been addressed on that. Therefore, our plea, in conclusion, Your Honor, is that this harassment through you should stop. I found you recently, I do not know whether it was before you, when we had the privilege to appear together with the Chief Justice Emeritus in the case of Rose and Jayne.
No, it was a different one.
You look like...
He's not my brother.
Yeah, you look like... Your Honor, Rose and Jayne is a very good case to refer to this time. When the magistrate, your brother magistrate, simply let her off. When he retired to consider submission, Rose and Jayne is a free citizen. She did not have to plead to a ridiculous charge. We ask Your Honor that Honorable Jayne Kihara, whom I know as a mother and a senior leader, she had serving her third term in Parliament, should not be before you for a misdemeanor. So we urge that when you retire to consider application, that you will let her off. In any event, you had the maximum sentence for such an offense, a fine of 5,000 shillings. A real misdemeanor. So we urge that you order immediate release of Honorable Jayne Kihara, and we ask our colleagues in the political space to just adhere to the Constitution. That's all we are saying. I thank you all.
All right, thank you, Sir Council.
Thank you, Your Honor, once again. It must be afternoon already. Good afternoon.
Good afternoon.
Your Honor, we oppose the application for deferment and or rejection of these charges. And Your Honor, while we respect our colleagues on the other side, and we must commend them for a very good arguments today, especially my learned colleague, Mr. Ndero, who I think must have preempted my arguments under Section 8. We've done this with him several times. I could see what he was doing. But Your Honor, I understand the application for rejection and or deferment of these charges to be founded either on Section 89, 4 or 5 by Mr. Ndegwa, or Section 134 by Mr. Your name is difficult. Not written. 89, 4 or 5, I think we could easily drop 89, 4, which deals with the drafting of charge. But 89, 5 about rejection of charges, or 134 as to, the propriety and contents of a charge sheet. And I thank Mr. Watuta for bringing 134 up, because Learned Senior Counsel has referred to a case before your brother, in which a charge was rejected on the basis of Section 89.5 on the same arguments, but which case from the onset we could say you're not bound by because it's a court of concurrent jurisdiction, it's not a superior court decision, and two, a decision which may have been issued in error, and I will tell the court why. The arguments, other than being based on sections 89 and section 134 of the Criminal Procedure Code, also is founded on a conflation of the criminal law vis-a-vis constitutional law of Kenya, and which needs some unpacking, a little bit of unpacking. And I'll say again that Mr. Ndegwa has done so well in his arguments on the constitutional perspective, which then exactly. But for all of us, any court can only do as much as they are provided to do in terms of jurisdiction. Without jurisdiction, a court downs its tools, in which case you will down your blue pen if you are asked to do something outside your jurisdiction. As correctly noted by Mr. Ndegwa, the jurisdiction of the Magistrates Court to hear and determine criminal cases is provided for under section 8, the jurisdiction of this court to hear and determine questions of alleged violation of the Constitution or of Bill of Rights is provided for under section 8. Interestingly, I was listening so keenly, my learned colleague goes to section 3, section 4, then he gets to 8 and tells you section 8.1. I want to read 8.1, which he referred to, if you permit me. I can go to another as they look for it for me, because it seems it's not in my bundle. My colleague is assisting me with it. But in a sense, what it says from the reading as we wait for the actual text is that the magistracy have the power to interpret and apply the Constitution. Yes, correct. Thank you, sir. 8.1, claims relating to violation of human rights. That subject to Article 165(3)(b), which I'll come to shortly, of the Constitution, and pecuniary limitations set out in section 7.1, a magistrate's court shall have jurisdiction to hear and determine applications. Hear and determine applications for redress of a denial, violation, or infringement of, or threat to right or fundamental freedom in the Bill of Rights. It does excellently well by bringing that out. But it leaves 8.2. Let's go to 8.2. The applications contemplated in subsection 1 shall only relate to the rights guaranteed in Article 25A and B of the Constitution. He deliberately ignored it because we've had this discussion. So that if there were allegations, if the arguments are based on alleged violations of rights or of the Bill of Rights or any provision of the Constitution, if they went outside Article 25A and B, this court must drop its pen in respect of all the other provisions of the Constitution. And that will include Article 10, Article 19, Article 20, Article 21, and Article 27, and 33. But I'll address 33 again shortly. Because you do not have jurisdiction to hear allegations of discriminatory charges, if at all, if that's what they are saying. You would love to, but the Constitution says no. Another fundamental and a very beautiful argument that my learned colleague has made today was in his element is that Section 94 was enacted on the first, became effective on 1st of August 1930. I must confess I didn't know, but I believe him. He's a good man. But he then gives the response and says there is section 7 of schedule 6, and it tells us what it says, that if there was a law existing before this constitution, then read it with the necessary adoption, alteration, or amendments to bring it into conformity with this constitution. So that answers the most difficult question he raised. Can we apply a law that was enacted in 1980? Today, the answer is yes, and the reason is section 7 of schedule 6 of the Constitution. To that extent, section 94 of the Penal Code, which was enacted in 1980 and which provides for the offense described in the charge sheet, then is still applicable today. And then there's another fundamental argument, again in its element, that one, you are at the same pedestal with the Parliament by dint of Article 10, that's correct. But that Parliament has been negligent And that because of their negligence, don't be negligent, help them out. Interestingly, the suspect is a member of parliament. It's very interesting. So that the suspect was negligent, leading to charges against her. But that is not by the wayside. Now, Article 2, which Senior Counsel refers to, and I'll refer the court to Article 2, I think sub-article 2 of Article 2, let me just look at it. And it says, no person may claim or exercise state authority except as authorized under this Constitution. You have no powers to make law. You have no powers to repeal laws. You have no powers to amend laws. That power belongs to Parliament. That Parliament which is inept and or negligent, in the words of the defense, is the only authority under this Constitution to make, amend or repeal laws. And related to that, therefore, is that as long as that law has not been repealed, it remains part of the law of Kenya. And if that argument is correct, and I believe it is correct, then the argument about Article 50, sub-article 2N, which is a very easy one to answer as we go on, that every accused person has a right not to be tried for an offense in respect of an act or omission, N, not to be convicted for an act or omission that at the time it was committed or omitted was not an offense in Kenya. This offense is an offense in Kenya since 1980. So until it is repealed, this court and the Office of the Director of Public Prosecutions has an obligation to enforce the law. There are very many fundamental issues of the Constitution. That's why I've taken some time on it. Then there is the question about Article 52B, which I'll marry with what I've just said about 52N. I have tried to persuade other benches of the judiciary, and I will try to persuade you today, that there was a deliberate intention to separate Article 49 and Article 50 of the Constitution. This is what I teach my law students at the Kenya School of Law in my guest lectures. That it was deliberate to separate the rights of an arrested person vis-a-vis the rights of an accused person from a commonsensical look of the Constitution. So that when Senior Counsel started giving his opening speech, he says, no, I should not call her accused, let me call her suspect for now. And which I agree with, that you are dealing with a suspect, not an accused person. Then that, if I persuade you, takes you outside Article 50 of the Constitution, which is the rights of an accused person. So that, in other words, we are saying the rights under Article 50 are triggered upon the taking of plea. That argument may not be correct, but we are trying to persuade you that it is correct. And I hope you are right. Because it is this court that makes that determination. So then, we have Article 52, Article 2B and 2N. We agree with our colleagues on the application of Article 25, that it cannot be limited by all means. But having spoken about there is the possibility of limitation of rights outside Article 25 by dint of Article 24 of the Constitution, that it permits the limitation of rights except Article 25 rights. I believe ours remains an open and democratic society, at least from my end.
You have from our end go to a contrary position.
I hope you will enjoy my submissions like I did his while just sitting.
Let's give him this.
So then that deals with, I think, all the areas I captured. There is the suggestion that Section 3 and Section 4 tells you that you are bound by Article 10 of the Constitution, which is correct. All state and public officers under this Constitution are bound by Article 10 of the Constitution. However, the application, because council tries to make a distinction between interpretation and application. But whichever distinction it makes, the application of Article 10 still must be within the jurisdictional limits of this court. You cannot just say that because Article 10 binds me, if the High Court is wrong, I can correct the High Court because Article 10 obligates all of us to defend the Constitution. So Article 10 must still be interpreted in line with other provisions of the Constitution and statutory provisions. But now we come back to the charge sheet, having done that constitutional analysis. You know, the reason I mentioned that your brother may have been in error in rejecting the charges under, by dint of the provisions of Section 89(5) against Rose Njeri. Of course, there will be a question whether or not the DPP appeal. That would be a different question. But this is why. The Honorable, allow me to read from my phone, Your Honor. I didn't know this would arrive, so I didn't bring copies, but I can supply these copies. In a decision by the High Court of Kenya in Milimani, Honorable Grace Ngenye Masharia, in the case of the Director of Public Prosecutions versus Kuldip, K-U-L-D-I-P, Kuldip Madan and another. This was a miscellaneous criminal application number 809 of 2018, and it is reported in the Kenya Law Reports in 2019. It has very many beautiful provisions which I would have loved to read, but I'll just go to a few of them, all the way from paragraph 28, 29, 30, 31, 32, 33, and 34. But for purposes of brevity of time, allow me to read 33 and 34. This is what the learned lady says, and this got me interested because it clarifies the applicability of Section 89, including 89(5) of the Criminal Procedure Code. And this is what she says. It is my view that the formal charges properly drafted by a police officer or a public prosecutor. I hope my colleagues can get it online and just confirm that I'm reading the correct thing. It is my view that the formal charges properly drafted by a police officer or a public prosecutor, as is currently the procedure in our jurisdiction, should be governed by sections 134 to 137, and that's why I appreciated Mr. Watuta for bringing 134 up of the Criminal Procedure Code. Even if these provisions do not expressly provide for rejection of a charge, that omission does not fetter the court's inherent powers to control its processes from abuse. This is in view of the fact that courts of superior jurisdiction have settled the jurisprudence that would render a charge sheet effective, which argument can be advanced before a magistrate to persuade the court to reject a charge. Therefore, nothing stops an accused from advancing that a charge sheet is defective within the scope of the settled law, after which a court may find accordingly. A magistrate, if persuaded to reject a charge, should also address himself to whether the charge satisfies Section 134 of the Criminal Procedure Code. That ought to apply to each charge in the incident application. But this is the most important 34. Having made my observation on the application of Section 89 of the Criminal Procedure Code, I feel that courts should not continue to apply this piece of legislation to reject charges. The provision no longer speaks to the current procedure used of bringing charges to court. It no longer retains the meaning it had when Parliament legislated it. In other words, the arguments under 89 collapse because the decision of Honorable Grace Ngenye Masharia binds this court. So that all the arguments under 89 fall by the wayside. And then that leaves us with Section 134 of the Criminal Procedure Code. Council has taken us through Section 134, but let me just look at it one more time. Every charge or information, in this case charge, shall contain and shall be sufficient if it contains a statement of the specific offense or offenses with which the accused person is charged, together with such particulars as may be necessary for giving reasonable information as to the nature of the offense charged.